next case set for argument this morning is the state of Ohio versus Larry Swaney. That's case number 18CA0056M. Both parties are represented by counsel. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal and certainly keep you apprised of how much time you have left. If you are going to reserve time, just let me know. You both know these arguments are recorded, so we ask that you keep your voice up and remain at the podium. We've read the briefs and are ready to proceed if you are.
Morning. May it please the court, I'm Attorney Mike Conway. As you know, I represent defendant appellant Larry Swaney. This is a criminal case where my client was accused of stealing time while he worked as a bus mechanic at Buckeye Schools during the month of September 2017. The jury found my client not guilty on theft in office count, but guilty of forgery, and we're here today to seek reversal of the forgery conviction on a number of grounds and assignments of error. I forgot, I wish to reserve 5 minutes for rebuttal.
All right, thank you.
The big issue here is the sufficiency of the evidence. There are two key witnesses for the state, Kent Morgan, the superintendent of the school board, and police officer Gerard. Their testimony is materially inconsistent and contradictory. Kent Morgan indicated that he accused my client of stealing time based on review of time cards where he signed off hours worked on weekends on September 2nd, 3rd, 5th, and the 9th, 2017. Compared to a video, he says he watched my client coming and going from work, and that video was from a camera located at the bus garage at Buckeye Schools, and he swore under oath that he saw this video, and he also swore under oath that he did not preserve the evidence. And he indicated that this videotape gets wiped every 30 to 45 days. That's what he said in his testimony. The problem is Officer Gerard, on the other hand, said that that videotape never existed because the camera was never online. So the defendant's in a position when dealing with this case where it has to call somebody a liar, because either that camera exists or it doesn't. Either Morgan saw what he did, or Gerard saw what he did, and Morgan could not have seen what he did according to Gerard. Gerard says, I'm telling the truth. There's no camera. And Morgan's saying he's telling the truth, but he didn't preserve the evidence. And then I made a discovery demand on November 2nd, which is very close in time to this 45-day time when the evidence would have been, quote, looped over or wiped. And the case was begun before that, during the same window when the evidence was still available and could not have been wiped, and they didn't preserve it. We can only assume that that bus garage videotape evidence, if it existed, was exculpatory, because if it was not exculpatory, they certainly would have used it as evidence in trial. They certainly used it to justify having my client indicted. Under the Due Process Clause, when the government does not preserve its evidence that could be exculpatory or undermines the confidence of the outcome of the case, conviction cannot be had, and conviction should be reversed. California versus Trombetta, Brady versus Maryland, and a number of state cases that I've cited. So that's one issue. The next issue is, in light of this, should the court have granted a motion for a mistrial when the government admits it did not preserve evidence it was using to charge my client with in a criminal case? The court should have granted a mistrial because the fundamental unfairness and the confidence in the outcome of the case was severely undermined by the government's conduct. That takes care of the mistrial. What about the Rule 29 acquittal? Same story. Here we got two witnesses contradicting each other on the same side of the case. That undermines the confidence in the outcome of the result. On top of that, Kent Morgan testified that my client was allowed to measure his time at the bus garage with his own time devices. My client used the clocks in the garage. The government prosecuted the case using camera number 2, which is a gate camera that's not on scene, that does not positively identify my client coming and going from work, to make the argument we saw a silver van that we know he drives. And they say they don't know that he drives it all the time. Morgan said that. But we see him coming and going using this camera system and the clock timer, and that's evidence that he's committing fraud to support a forgery conviction because the timesheets don't match the clock hours on camera number 2. The problem is camera number 2, everybody admitted, was not used to measure my client's hours at work. That was not the clock system that my client used to record his time at work. He was never told to do that. He was not even aware of that camera system. So here we've got a situation where the government has used evidence that does not prove anything. Their video timer on the videotape is very nice. It may show relevant time on the videotape, but that may not be the accurate time that was in the bus garage that my client used to measure his work hours.
Was there any testimony about the accuracy of that clock?
Your Honor?
Was there any testimony about the accuracy of the garage clock?
Yes, Your Honor. My client took the stand and he testified to use one of those clocks. Matter of fact, there's 3 clocks in that garage at 3 different times. But Morgan said my client was allowed to use the clock that he wanted to measure his time at work. Okay, so we have a reasonable doubt about whether or not my client defrauded anybody. The only evidence of alleged fraud, there's only 2 things. It's either the time cards or the video clock on camera number 2. And the most unreliable thing is camera number 2, because the clock on that camera, they did not prove was synced with any clock in the bus garage. The jury should not have convicted my client. And the government should have preserved the video evidence from the one that Kent Morgan used. And if that evidence never existed, according to Gerard, they should have indicated to the jury that Morgan told a lie, because someone is not telling the truth. And it's either Morgan or Gerard. And I don't think Gerard used a clock system that was not synced, so it's not reliable. But Morgan said he used a clock system on a video that Gerard said didn't exist. How can you convict somebody on this evidence? There's a reasonable doubt right there.
Is that a credibility decision to be made by the jury?
No, we're on appeal, Your Honor, and in a manifest weight theory, the court has to weigh the entire record. And if you weigh the entire record, and you look at the obvious inferences from this evidence, I think you'll find there's big gaps. And there's places the jury should not have gone. They did not find him guilty of theft in office, which I'm scratching my head over. If they said he didn't commit a theft offense, how could he have been convicted of forgery on the same exact evidence? And a forgery charge presumably takes more. It takes evidence of deception. And I realize, of course, that the jury's free to choose which count it wants to convict him on. But it's incongruous. And in light of the witness testimony, it doesn't make any sense. So I respectfully request that this case be reversed and the conviction vacated. I don't think my client got a fair trial. I think his due process rights were violated. This also comes after this charge that my client was accused of comes within a week or 2 of him making a complaint about disability discrimination against the school board, which the trial judge would not let me go into on any cross-examination. And I submit that, although I didn't assign it as an error, it's just part of the circumstances in the whole record that you can weigh under manifest testing that shows that a witness had a motive to go after my client to get him convicted for some ulterior purpose, and then that same witness, Kent Morgan, says, I didn't keep the evidence that I'm using to convict your guy. So I respectfully request that this case be reversed and the conviction vacated. Thank you.
Okay, you'll have your full 5 minutes for rebuttal. State of 15 minutes.
Thank you. Good morning, Your Honors, and may it please the Court. I'm Vince Felucci with the Medina County Prosecutor's Office for the appellee of the state of Ohio. In terms of the sufficiency of the evidence, I think there was a little bit different focus with the oral argument than there was in the brief, which talked a lot about, well, it was inconsistent for the jury to find him not guilty of theft in office, but guilty of forgery. But to be convicted of forgery, there's no requirement that a defendant also commit a theft. These are, no authority supports that point. These are two very different and separate crimes that have very multiple different elements to prove them. Swaney cites this 8th District case, Geiger, which doesn't say this proposition at all, doesn't stand for that proposition at all, and the facts are very distinguishable. In fact, there's some very unique facts in that 8th District case having to do with police routinely using each other's time cards and things like that. There's some very convoluted facts there that have nothing to do with what happened here. What happened here, the evidence here was very simple. The state of Ohio proved that on at least 4 different dates in September of 2017, Swaney forged his timesheets so that he'd be paid for time that he didn't work. The evidence was that on September 2nd, first of all, so it's the 2nd, it's the 3rd, it's the 9th, and it's the 16th of September. So on September 2nd, Swaney records a time in on his timesheet of 9 a.m. and a timeout of 3 p.m. School surveillance video from this camera 2, as it was referred to, it shows that Swaney actually arrived at 9:12 a.m. and actually left at 2:07 p.m.
Counsel, that was the video that was used at trial, right?
Correct.
Okay, but the original video that was used for the indictment was not available.
That's not
Okay,
true.
Explain to me.
So Superintendent Morgan views this other camera first. He views it, but it doesn't end up getting preserved. He sees these same times, essentially, where he's arriving too late and he's leaving way too early. And he's marking these false times. He sees that. He's not familiar with how this video system works. He hasn't consulted with Deputy Gerard yet, who is the school resource officer.
And this is all testified to?
Yes. He's got this little room where he can see all the cameras, and he's the one that's familiar with all these cameras. I think how it's originally brought to his attention was he happened to be driving by on a Saturday when Mr. Swaney was working, and he sees that he sees when he's leaving, I believe, and he thinks, okay. I don't think he thinks much of it, but then he sees the time card and he sees, okay, that's not when I actually saw him with my own 2 eyes. Then he goes and he verifies on this camera that's a little bit closer, I believe, to the bus garage, and that camera footage ends up being automatically looped over as it normally does, and so they weren't ultimately able to save that footage, but there was, or preserve that footage for trial. There's a second camera called camera 2 that's actually at the middle school, but it's pointing directly at the bus garage as well, and it's just as good by all indications in the record, and that's what's actually played at trial, is that camera footage from all 4 of these dates, and Mr. Morgan testifies about the first camera. Deputy Gerard more testifies about the second camera that he ends up reviewing, because he gets brought into this a little bit later, and he's essentially working off of this second camera. So it kind of goes on like that. September 3rd, he records a time in of 10 a.m., a time out of 3:30 p.m. The camera 2 footage shows that he actually arrived at 10:40 a.m. and actually left at 2:27 p.m. without returning.
Is there any evidence presented that there was concerns with this beforehand, the reason why they had looked at it or anything?
I don't think there really were concerns.
Did they go back and look at the previous time cards to see if there's any discrepancies?
You mean previous to September of
Yes, I'm sorry.
2017? I don't know if an answer to that is in the record. In terms of,
Because I'm gonna be honest with you, it seems pretty minor. I was expecting to see, I'm not saying it still may not constitute a forgery, but I was expecting to see like, months of this, or, like 3 hours here, 4 hours here, and then next thing you know, you have 20 hours or 30 hours or whatever. And so you have 3 dates with just a couple hours basically altogether.
well, I think it was suspected that this probably had been going on for some time based on what was happening.
But there's no evidence.
But the cameras, like I said, they wouldn't have the cameras going back that far because they'd be automatically.
But what about camera 2?
erased. Well, they were able to preserve that footage.
That's what I'm saying.
Deputy Gerard got involved, apparently.
Camera 2, was the evidence that it automatically looped over to?
There was, I don't believe there was evidence either way on that, but just that they did have it preserved, that did not happen to camera 2, that did happen to the other camera. I'm not even sure, thinking back about the record, I don't think there's, in terms of, are they the same kind of camera? I don't believe there's evidence either way on that.
But there was no evidence presented, nobody asked if they had looked at prior time cards and compared those to any camera footage.
I do not believe so.
Thank you.
Now, Swaney actually testified in his own defense at the trial, and he made some very important and damaging admissions for his case. He admitted that he created all these timesheets, first of all, so that wasn't a dispute. He admitted that he worked on all of these days that were in question in September, and admitted that it was his van that was shown on the surveillance video that was going in and out of the garage, so that wasn't a dispute. This whole thing about using a different clock than the one that was on the surveillance video, but Swaney never explained the difference, if there was any at all, between this clock he says he was going off of and the clock on the surveillance video. The discrepancies we're talking about here are not a few minutes, they're whole hours, or more than whole hours. So 2 different clocks might be expected to have a discrepancy of a few minutes, but not of whole hours. And he never.
Well, when's their whole hours? You said maybe half an hour or so, but when was there more than 1 hour?
There was, on a few occasions.
Because there was only 4 dates, right?
Right. Well, you look at September 9th, it's 54 minutes. Well, it's an hour and a half, and then it's at the beginning of the day, and then it's 54 minutes at the end of the day.
Okay, so what was the time then? Do you have it written down?
September 9th, he records 7 a.m. Arrival and 3 p.m. leaving, but the surveillance video shows he actually arrived at 8:34 a.m. and left at 2:06 p.m. So I think I already read September 2nd. September 3rd, he's recording a time in of 10 a.m. and a timeout of 3:30 p.m., but the video shows that he arrives at 10:40 a.m. and leaves at 2:27 p.m. So that's an hour early there, 40 minutes late in the morning. You look at September 16th, he records a time in of 9 a.m. and a timeout of 2:30 p.m. The surveillance video says he actually arrived at 10:30 a.m., so an hour and a half late, and he leaves at 1:25 p.m., so more than an hour early on that day.
Thank you.
So we're certainly not talking about a few minutes, and there was never any argument that someone failed to turn the clocks ahead or back or anything like that. There's no even trying to argue that, or certainly no evidence of that. There's no testimony, as Judge Teodosio was wondering, there's no testimony about the accuracy or inaccuracy of that clock that is inside the bus garage. There just wasn't. There's no evidence of that.
Did the state have the request for discovery prior to the tape being overridden or taped over?
No. The state never had, in terms of the prosecutor's office, certainly when the case is going on, they never had this first camera video. This was looped over
Well, I guess my question is, was the discovery request made in such, at a point in time when the state could have obtained the video and preserved it?
No, absolutely not. The state would not have had this available. It wasn't even available throughout the investigation when Deputy Gerard had gotten involved. It had been looped over. So certainly, whenever a discovery request that would have been made during the case, that was not available to the state of Ohio. I guess that gets into the Brady claim,
Right.
which has to do with this a mistrial motion made that was correctly denied. There's this claim that doesn't have any evidence that the failure to preserve that video by Mr. Morgan, that was an intentional, some kind of nefarious act on his part. There's no evidence of that. There's no evidence that any video was improperly suppressed or intentionally destroyed in this case. That's a wild conspiracy theory, basically, that's being propagated here.
Well, I was gonna ask you too, as a follow-up to Judge Tudoso's question, when Officer Gerard, is it officer or deputy, I can't remember. Deputy Gerard became involved, you said he went off of the camera too. How long was it after the superintendent discovered the discrepancies under the bus garage camera until Gerard was actually involved in the case, or a police report was made, I should say?
I think it was a matter of a week or two. I don't think it was long. I don't know the exact time though. I don't remember the exact time, but it wasn't. I don't think it was a terribly long time.
And by that time, the camera, the video on the bus garage camera had already looped over, you're saying?
That was Mr. Morgan's testimony, yes. And it was uncontroverted testimony, by the way. There was nothing to dispute that. The jury had the right to observe him and judge his credibility. Like again, that as was mentioned, that goes to weight of the evidence, and clearly the jury found enough to convict here of forgery. All of the circumstances here demonstrated that Swaney's purpose here was to defraud the school. That's what you need for forgery. You look at the definition of defraud. Swaney obtained by deception a benefit to himself, detriment to the school system. He was paid for work that he didn't do based on forged timesheets. If you look at the definition of, if you go to deception then, Swaney deceived the school system with a false representation. You look at the definition of forge. Swaney fabricated writings that were not authenticated by his conduct. Again, if you go to weight, Swaney, as I mentioned, he harmed his credibility, I think, significantly. I already mentioned all the omissions he made that were helpful for the state, but he actually tried to say on the stand that it could have been his son driving the van in the video, his son Sean. But Sean himself actually testified for the defense that he wasn't in the bus garage on any of those days in question. So if Swaney was willing in open court to basically construct a scenario to the jury that he knew wasn't true, and his son confirmed wasn't true, it probably was not a huge leap for the jury to believe that he purposely forged his timesheets. When he was asked if he thought his timesheets corresponded to what was on the surveillance video, he could only answer, "I don't know." And of course, we know that they didn't, and I would submit that's not much of a defense. Swaney's third witness that he puts on, this James Tighe, he had only worked with Swaney until March of 2017, and basically said he had no problems with him.
You got about 30 seconds.
But the forgeries in this case didn't happen until September of 2017. So his testimony, I submit, had no relevance to his defense in terms of weight. Just briefly on assignment of error 3, that was not a confrontation clause issue, just the simple fact that this video did not exist. Essentially what he's arguing there is that he could have better cross-examined Mr. Morgan if he'd had this video. Well, that's not a confrontation clause issue, it's not implicated here, there's no witness or hearsay declarant that Swaney didn't get to cross-examine. Swaney did actually get to cross-examine Mr. Morgan on that fact that there was no video, no first video, and the jury could take that fact into account when they were considering the weight of the evidence.
Your time is up.
Thank you.
Thank you. Counsel, you'll have your full 5 minutes for rebuttal.
Thank you. First thing I'd like to point out is that in a forgery case, you have to show something was taken by deception. That's the same thing as theft. I do not know what they're talking about when they say theft isn't an issue in a forgery case. As far as the, they said my client never explained the difference between the video clocks and the garage clocks. First of all, my client never had access to the original videotape. And secondly, never even knew about camera 2. And we never had an opportunity to test it or anything. Not that it would have even mattered because there's no evidence and the government has the evidence to show its time taking is accurate, not the defendant. They didn't show that that video on the camera 2 is synced with any clock in the garage. My client, Morgan, admitted was allowed to use to measure his time. The government never explained why there's no punch-in, punch-out clock system for its employees at the bus garage. Instead, they are using a video taped from a camera after they indicted my client to make the case that he wasn't there working when he said he was. And that is, that's the height of unfairness. Because Morgan said that he's not required to use the government's time measuring device, something they chose to measure his time. He's free to use his own clock system, which he did. And they're now saying that, well, because your clock doesn't match my clock, you're guilty of fraud. Well, or forgery. That, you can't square that. They gave him a right to use his own time measuring device. There's no evidence whatsoever that the clocks Swaney used were wrong, which means these time cards were right. And if the government's saying that we're honest, then why don't you preserve the original tape? The indictment in this case came down, had it here, hang on. The government in the indictment in this case came down, I believe it was on October 18th. Yes. The indictment was October 18th. According to Morgan, not only did he say, contrary to the government's position on appeal, that he was trained, says that at 117 in the record, page 117. Not only was he trained by the vendor to operate the camera system, he also testified that the camera loops over every 30 to 45 days. That's at 110 of the record. At 110 of the record, that is. And so, here we got a guy who says, I'm relying on this evidence to accuse someone of a crime. I don't preserve it. And then he looked at this, according to the record, on September 22nd. If you take 45 days past that, it puts it past the date he was indicted. That videotape evidence was in existence on the date the grand jury made a true bill in this case, and they didn't preserve it. And now they want the court to believe that this is all honest conduct. The jury should have held that against the government in this case. I'd also like to point out that my client testified he started work early, and that was what TIDE was called to verify, was that my client had really good work habits. He always came to work early, started in early before he even started logging his time. And as far as his son, Sean, when Swaney was talking about his son driving his van on occasion, he didn't specifically say it was the days he was accused of in this case. He just said he does that on occasion. He was responding to that because the government was trying to get him to admit he was driving the van out the gate on the days camera 2 said he was, and my client didn't agree with that. So it wasn't me. That's the government's problem to resolve, not my client's. My client was asked, was that you? And he said, I don't know, could have been my son. He's entitled to deny the accusation against him when they can't prove otherwise. And in any event, they can't prove the case anyhow because there's no evidence that the clock that was used to accuse him of not being at work when he said he was is not the same measuring device he was using to record his time that the government said he's allowed to use.
20 seconds.
As far as the cases I've cited in my motion, they all point to one thing, and that is about undermining the confidence of the court system when the evidence that is being used to accuse somebody of being guilty is not preserved to allow them to confront it. My client did have a chance to cross-examine Morgan. Morgan did admit he didn't preserve the tape, but had that original tape been preserved, we might have been able to show that Morgan was even less credible than we already proved he was. We could have added to it because of the fact that that video may not have shown what Morgan says it did. That is a denial of confrontation. So respectfully request this case be reversed. Thank you.
Thank you, counsel. Thank you both for your arguments today. The court will take the matter under advisement, issue a decision in due course. We will certainly, or the clerk of courts, I should say, will certainly mail you both a copy on the day it's released. The opinions are also posted on the Supreme Court of Ohio's website. We want to thank you both for your arguments.
Thank you.
Thank you.